the truth is, we know that this committee majority is not acting in good faith. How? Because they're moving for contempt for an attorney general failing to turn over material that this majority, at least some, maybe it's just the staff, but some people know that you can't hold someone in contempt. You can vote to do that, but you can't be in contempt for failing to produce things that are illegal for you to produce. How do we know? Somebody over there knows that this is wrong, is because there was an offer. Look, Attorney General Barr, if you'll join us in going to court and getting a court order so that we can get the grand jury proceedings and evidence, then we will disregard the contempt. Well, that's evidence of a state of mind by the majority that at least somebody over there knows you cannot be in contempt for failing to produce what would be illegal to produce without a court order. You're on the wrong side of history. And there is no joy here in seeing the abuses. I hope and pray literally for the day when we can join forces and quit trying to push this idea of an attempted coup and uncover the abuses that have truly gone on. My time's expired. The committee's has too.
Bill Barr is following the law, and what's his reward? Democrats are going to hold him in contempt. I don't think today's actually about getting information. I don't think it's about getting the unredacted Mueller report. I don't think last week's hearing was actually about having staff question the Attorney General. I think it's, as my colleague said earlier, I think it's all about trying to destroy Bill Barr because Democrats are nervous he's going to get to the bottom of everything. He's going to find out how and why this investigation started in the first place. Never forget what Bill Barr said a few weeks ago, 3.5 weeks ago, when he testified in front of the Senate Finance Committee. Said a lot of important things, but he said four very interesting things. First, he said there was a failure of leadership at the upper echelon, term he used, upper echelon of the FBI. We all know that's the case. Director Comey's been fired. Deputy Director McCabe fired, lied 3 times under oath, according to the Inspector General. FBI counsel Jim Baker demoted and left, currently under investigation by the Justice Department. Lisa Page demoted and left. Peter Strzok, deputy head of counterintelligence, demoted and fired. Peter Strzok, the guy who ran the Clinton investigation and the Russian investigation. There was certainly a failure of leadership at the upper echelon of the FBI. Second thing the Attorney General said 3.5 weeks ago in front of the Senate Finance Committee. Spying did occur. Said it twice. Yes, spying did occur. Third, he said, there's a basis for my concern about the spying that took place. And maybe the most interesting thing, 2 terms he used that frankly I find frightening. He said there was, in his judgment, he thinks there may have been unauthorized surveillance and political surveillance. Scary terms. We got to go back to January 3rd, 2017. Senator Schumer on the Rachel Maddow show talking about then President-elect Trump says this: if you take on the intelligence community, they have 6 ways from Sunday at getting back at you. Now, I don't know if the FBI went after President Trump in 6 ways, but I sure know they went after him in 2 ways. And the first one is the now famous dossier. On October 21st, 2016, the FBI used one party's opposition research document as the basis to go to a secret court to get a warrant to spy on the other party's campaign. That happened. Democrat National Committee, the Clinton campaign, paid Perkins Coie law firm, who hired Fusion GPS, who then hired a foreigner, Christopher Steele, who did what? Talked to Russians and put together this salacious, unverified document that became the basis to get a warrant to spy on the Trump campaign. They did it. And when they went to the court, they didn't tell them important things like who paid for it. They didn't tell him that Christopher Steele had already told the FBI and the Justice Department that he was, quote, desperate to stop Trump. And they didn't tell the court that Christopher Steele had been fired by the FBI because he's out talking to the press. They did that. And second, just last Thursday, New York Times story, FBI sent investigator posing as an assistant to meet with the Trump aide in 2016. FBI sent someone in, pretending to be somebody else, to talk with George Papadopoulos, who was with the Trump campaign. You know what they call that? You know what they call that? It's called spying. They did it. They did it. They did it twice, and who knows how much more. And what I know is Bill Barr has said he's going to get to the bottom of it. And think about the term he used again. This is important. Political surveillance in the United States of America. I will not yield. Think about that term. He's going to get to the, he said he's going to put a team together, going to investigate all this. This is critical. And never forget the guy who ran this investigation, Peter Strzok, ran the Clinton investigation and then launched and ran the Trump-Russia investigation. Never forget what he said. Trump should lose 100 million to zero. We need an insurance policy. Told Lisa Page, don't worry, Lisa, we'll stop Trump. This is what Bill Barr wants to investigate. And as my colleagues have said, this is the House Judiciary Committee, with the history this committee has in protecting fundamental liberties and protecting the Constitution. Last week, there was another important document Emmett Flood sent to the Attorney General. I just want to read a couple sentences. Under our system of government, unelected executive branch officers and intelligence agency personnel are supposed to answer to the person elected by the people, the president, and not the other way around. This is not a Democrat or Republican issue. It's a matter of having a government responsible to the people, to we the people. In the partisan commotion surrounding the Mueller report, it would be well to remember that what can be done to a president can be done to any of us. And this committee is supposed to look out for that fundamental fact more than anything else. And we are not doing that today. I yield back.
I would simply observe that, to his credit, Mr. Jordan has been second to none in asking for access to the materials we're asking for the, and I simply ask him, does he still think is he still supporting his own request for that the committee and the Congress be given access to the entire report and the underlying information?
Consistent with the law, and I would ask the chairman. My understanding is Mr. Mueller's going to be here next week. Why are we doing it? You're going to get to ask the guy who wrote the whole darn document. We're all going to get asked him questions. Why don't you hold off on this contempt until at least the guy who wrote the thing spent 22 months and $35 million with a whole bunch of Democrat lawyers putting it together? Why don't you wait and ask him next week before we do this contempt resolution?
I'll answer, well, essentially because it would be useful to read the material before we have him in front of us.
Glad to see that the microphone's working this week. My good friend from Georgia just asked the operative question. How can we impeach if we don't get the documents? How can we impeach if we don't get the documents? Ladies and gentlemen, this hearing is not about the Attorney General. It's not about the Mueller report, 92% of which everyone in America has had the opportunity to read. It's not about the fact that even the portions that the American people haven't been able to read, the chairman's been able to go read had he chosen. This is all about impeaching the president. Now, why don't they just say it? Why don't they just jump to the impeachment proceedings like their liberal media overlords are telling them to do? Well, the reason is that the American people don't support impeachment. And it's easy to understand why. They actually went and elected Donald Trump president of the United States. And I don't think people are going to support impeaching a president who's doing so well. I mean, you got 3.2% growth in the economy. The Trump economy is hot. And the reason we're doing so well is as a consequence of the president's policies. And so at a time when my Democrat colleagues are focused on the next election and not solutions to the problems facing Americans, they can't attack the president's policies because people are doing well. So typically they roll next to identity politics, that based on what you look like, who you pray to, or who you love, you can't possibly support Republicans. But African Americans are doing better. Hispanics are doing better. Women are doing better. We are seeing a rising tide that is truly lifting all boats in this country. And so now we have this effort, not to argue with policies, not to typically go to the identity politics that functions as the organizing principle of today's Democratic Party. They have to delegitimize the guy that won, delegitimize the guy that people voted for, but they don't have the guts to do it directly, and so they're going after the Attorney General. Now, the gentleman from Georgia in his last remark said, we are hiding behind the rules. Hiding behind the rules. These are federal laws that dictate what the Attorney General can and cannot do. We're not hiding behind the rules. We just like to follow them. By the way, it's not following the rules that got us in this trouble in the first place. When the Inspector General testified before us, he said it's the fundamental fact that during the investigations of Hillary Clinton and Donald Trump, you saw continuous examples of a one-off here, a violation of protocol there. The Inspector General said never before had he seen a circumstance where the very same team that was investigating Hillary Clinton would then go and investigate the other person that was involved in the 2016 presidential contest. About a month ago, in this committee, I laid out the stages of grief: denial, anger, bargaining, depression, and acceptance. And I think that folks watching at home can probably follow along and see where we're headed. First, my Democratic colleagues were in denial. When they saw that there was no collusion after saying for 22 months that the president was an agent of the Russian government, after saying for 22 months that there was actual evidence of collusion, they were in denial when they saw the conclusion that there wasn't. Then there was anger. It had to be the Attorney General's fault. Mueller didn't make a decision on obstruction. Somebody had to. The Attorney General did. So they got mad at him. And we had this whole kerfluffle of anger. Well, now we know the third step: bargaining. Well, Mr. Attorney General, you've given us 92% of the Mueller report, but we have to bargain for the remaining 8% because that's really where we think the action is. Well, Mr. Attorney General, you spent 5 hours before the Senate Judiciary Committee. 3 of our presidential candidates got to question you. You offered to come before the House Judiciary Committee. You offered to come for an additional hour of questioning, but we have to bargain so that our staff lawyers can ask you questions. Now, I don't think it's a good sign that the next sign after bargaining is depression. So I feel for my Democrat colleagues, but after that we get to acceptance, and that's sure something that I'm looking forward to, because there are some really good ideas that my Democratic colleagues have once they kind of get to acceptance on the no Russia collusion thing. My friend, the gentleman from Rhode Island, has excellent ideas about how to change the way that consumers interface with big tech companies. My colleague from the state of New York is right, that if the First Step Act is the only Step Act, then that would be a bad thing. We need to do more on criminal justice reform. My colleague who's not with us from California, Mr. Swalwell, he's got great ideas to unlock potential cures with medical cannabis reform, but we're not doing any of those things. And by the way, I bet a bunch of my friends on the other side of the aisle low-key wish that their actual bills that would impact the lives of Americans would get heard instead of this garbage. The Obama administration ran an intel operation against the Trump campaign. Peter Strzok opened it up, the dossier kept it going, and now the Democrats need to get over it. I yield back.
I've been taking notes as my colleagues have commented on all of this. Congresswoman Sheila Jackson Lee said the executive branch is, quote, taking a wrecking ball to the Constitution. And Mr. Chairman, you said that the DOJ doesn't recognize Congress as a co-equal branch of government or acknowledge our oversight responsibility. Mr. Cohen said we're trampling upon Article 1. Anyone who looks at these facts objectively knows the truth is exactly the opposite. The Attorney General and the DOJ are objecting to this charade based upon the rule of law. They are trying to protect the integrity of our institutions. And Mr. Chairman, you said that the preliminary protective assertion of executive privilege this morning was a last-minute outburst. It's exactly the opposite of that. In fact, the letter that the DOJ sent to you this morning says, and I quote, regrettably, you, Mr. Chairman, have made this assertion necessary by your insistence upon scheduling a premature contempt vote. The letter goes on to say, you've terminated our ongoing negotiations and abandoned the accommodation process. And as we have repeatedly explained, the Attorney General could not comply with your subpoena in its current form without violating the law. court rules, and court orders, and without threatening the independence of the Department of Justice's prosecutorial functions. That's a quoting from the letter. The facts matter. The letter that the Attorney General sent to the President this morning that accompanies all this says, quote, "The committee demands all of the special counsel's investigative files, which consist of," everybody listen, consist of millions of pages of classified and unclassified documents bearing upon more than 24 criminal cases and investigations, many of which are ongoing. These materials include law enforcement information, information about sensitive intelligence sources and methods, and grand jury information that the department is prohibited from disclosing by law. That's the letter the Attorney General sent to the President explaining all this. Look, we're attorneys on here. Most of us are attorneys on this committee. What does the law say? The courts have repeatedly affirmed the rules on all this. April 5th, just last month, the U.S. Court of Appeals for the D.C. Circuit ruled in McKeever versus Barr that district courts may disclose grand jury materials only where they have positive authority to do so, particularly through the exceptions to grand jury secrecy listed in Rule 6E. The Court of Appeals explained the vital interests, they said, that the rule of grand jury secrecy seeks to protect, including preserving the willingness and candor of witnesses called before the grand jury, not alerting the target of investigation who might otherwise flee or interfere with the grand jury, and preserving the rights of a suspect who might later be exonerated. These are critically important principles and traditions for us to uphold, and it is, again, the law. That the chairman can file suit for access to the 6E material, but instead he blasts the Attorney General for not joining him in doing so. Why hasn't the chairman taken that step? I think I know why. Perhaps because he knows that his rationale for demanding the unredacted report is wholly insufficient. Look, this bears repeating. The chairman claims he needs the full unredacted report as part of the March 4th, 2019 investigation into the 81 individuals and organizations related in some way to President Trump. But let's make a couple of facts clear. The investigation, we don't even know if it's still ongoing. We haven't heard much about it lately. The lack of activity surrounding the investigations makes clear the majority here is not interested in pursuing this for any legitimate legislative purpose. This is about scoring political points. The chairman's public comments surrounding his need for the full report are almost exclusively focused on obstruction, but another important fact here, 99.9% of the obstruction volume is available right now for the chairman to view, but he hasn't done that. Only 6 lines and over 182 pages is redacted in the obstruction volume. This is not about seeking the truth, as we've heard this morning. It's about raw partisan politics. Our Democrat colleagues have weaponized our critical oversight responsibilities. And moving today to hold the AG in contempt is not only premature, unprecedented, and unwarranted, frankly, it is shameful. I think, we believe, the American people deserve better. I hope that they'll review the facts. I hope they'll look at all this correspondence. I hope they'll get beyond all this cloud of partisan politics and understand why we are taking the stand today that we are. I yield back.
Last week we saw an attempt to change the rules of this committee that defied the historical precedent of by applying only impeachment proceedings to Attorney General William Barr. And today we're zipping right along, and we know that my colleagues on the other side have the votes. They're gonna try to hold this Attorney General in contempt. But I'm interested to see the look on the judge's face when my colleagues from the other side present these facts. The court's going to say, "What'd you do? Were you in negotiations?" Well, we were, but we scuttled that because we refused to hear from the Attorney General because we changed the rules. Judge, we changed the rules so the Attorney General didn't come in. He offered to let us view the less redacted report, but I didn't do that. I didn't even bother to go down there and look at that report. He offered to have staff members view the less redacted report with me. I said, no, we're not going to do that either. He permitted us to take notes on the less redacted report, and we rejected that as well. He asked us to continue to negotiate, see if we could work out our differences, but I rejected that as well. We attempted to compel him to respond in spite of federal law on Rule 6E, the grand jury material we've heard so much about today. We knew that there were some other witnesses that were important that might have shed light on this as well, but we didn't hold a hearing with DAG Rosenstein. We didn't hold a hearing on Mueller before we issued our contempt citation. We didn't seek closed-door, confidential, classified hearings with any of these individuals. In fact, Judge, you know what we did? We undercut our whole argument by making the argument to Mr. Barr, saying, hey, look, you know, Mr. Barr, why don't you just join us? Why don't you just join us in asking the court to authorize release of 6E material? What does that do? It says, quite frankly, that the folks that will be sitting there before a court propounding execution of a contempt citation, they're going to have the great privilege of saying, yeah, we put a sword of Damocles over William Barr. We created a Hobson choice. We said, guess what, Mr. Barr? You either get held in contempt or you violate federal law. Because that's just the way we do things in the Judiciary Committee these days. That's just the way it is. That is unprecedented, and it will hold this committee up to derision. And as my colleague, Mr. Johnson from Louisiana, said, there was a case that just came out last month which said, and this gets to my colleague from Georgia who said, you can't be misled, there are exceptions. That's right, and the court said you must fit within one of those exceptions before you can release Rule 6E material. But don't be misled, because nothing we're doing here today fits in to the Rule 6E exceptions. There's not an authorization under the 6E provisions right now. So there's going to be a problem, and I can't wait to see the look on the judge's face when these guys try to explain, well, we were trying to pigeonhole into something that's 6E. And then I'll just close in this area. When I hear that the wrecking ball is being taken to the Constitution, that it's being trampled upon, that we're a continued breakdown of constitutional order, these kind of arguments made over and over again, I can't help but say, if you think this administration, this president is so dangerous, why aren't you acting on the many resolutions for impeachment you've already introduced? I mean, Mr. Johnson was pretty clear. This whole thing is about impeachment. Well, take it to the American people. Take it, file your resolution. You've already filed them. Act on them. With that, my time is up. Thank you.
This subpoena puts the Attorney General in legal catch-22. To comply with the subpoena, he must break the law. If he obeys the law, he must disobey the subpoena. Now, every person on this committee knows that the law forbids release of grand jury testimony. Congress is the law-making branch of government. If this committee feels it's so important to see the grand jury testimony, it can change the law. But it cannot order the highest-ranking law enforcement official in our country to break that law. You know, the American people can plainly see what's going on here. For 2.5 years, they have been force-fed a brazen and monstrous lie that the President of the United States is a traitor who's loyal to a foreign and hostile power. Robert Mueller was given extraordinary powers to investigate this. He appointed one of the most partisan and biased teams of investigators that has ever been appointed to substantiate these charges. They spent 22 months and $25 million in direct and component costs doing so. They employed some of the most abusive tactics, among them perjury traps and threatening family members, in order to turn up some shred of evidence to confirm this narrative. The Trump administration gave them every document they requested and even waived attorney-client privilege to make the president's personal attorney available for 30 hours of testimony. Though the president had the clear constitutional authority to terminate or interfere with the investigation, he did not. Well, after all that, they were forced to admit that there's not a shred of evidence to support this lie. We're now learning it was predicated on a fake dossier fabricated by the Clinton campaign and was used by the highest-ranking officials of the Department of Justice, the FBI, our intelligence agencies, and perhaps even the White House. First, to try to influence the outcome of our election, and after failing that, to undermine the duly elected President of the United States and tear this country apart. Now that lie's laid bare for all to see. The left's had now to think up a new lie, and think it up quick. Thus, in a heartbeat, the lie changed from collusion to obstruction. That even though the administration did nothing to interfere or impede the investigation, the president is guilty of obstruction just because he complained about the injustice of it all behind closed doors in words that amounted to no action whatsoever. They know this lie won't hold up under scrutiny either. So what to do? Well, the answer to that question is before us right now. Even though there was no legal requirement for the Mueller report to be released publicly, the Attorney General has released it with the sole exception of material he is legally forbidden to release, amounting to 92% of the document. He's offered the chairman and the ranking member of this committee the opportunity to review the additional redactions that can be reviewed in a classified setting, leaving only about 6 lines out of 182 pages. But instead of reviewing that information or changing the law to allow for its public release, they order the Attorney General to do what he legally cannot do and then charge there's a cover-up. They imply the smoking gun is now in that 6 lines and over 182 pages that cannot be legally shared, safe in the knowledge they'll never be called out on it. And they hope that there'll be enough of a smokescreen to cover the perversion of our justice and intelligence agencies for political purposes under the Obama administration. One other point. Last week, the Democrats voted to change the rules of the committee to allow members to hide behind committee counsel to challenge the Attorney General. Mr. Chairman, we don't hire people to speak for us on the House floor, and we shouldn't hire people to speak for us in committee. Only members of the House should speak in House proceedings, and there's a reason for that. We're responsible and accountable for what we say in public forums. In this public forum, hired help is not. The only rightful exception is when we sit as a tribunal, an impeachment, because then we're sitting as a jury to hear evidence. Any exceptions from this makes a mockery of representative democracy based on the direct accountability that representatives of the people must have to those who elected them. I yield back.
Well, why don't we go to one more person?
What do you think of the way Attorney General Barr has behaved?
And I think he acted in a way that's less than honorable in the way he described it in writing and described it during a press conference and continues to talk as if he's the president's lawyer. That is not the Attorney General's job.
William Barr, less than honorable. Your response?
Well, I've had many disagreements with Jim Comey. Jim Comey, I think, takes some steps when he was a part of the FBI that he probably shouldn't have. I think where we are in all of this is it's time to have Mueller come to Congress and explain and talk about and be able to ask him questions to understand the perceived differences between his opinion of the Mueller report and the interpretation that was done by William Barr. The Judiciary committees are the committee where that should happen, and I would hope that all the members of the Judiciary Committee, especially senior Democrats, would actually go in and read the less redacted version of the Mueller report that has already been provided. I think there is a version that only has 7 lines, marked out that senior Democratic leaders are able to view. Let's do that. Let's hear from Mueller. Mueller. And then also what we need to be talking about is how are we going to deal with what Republicans and Democrats actually agree on? That the Russians try to manipulate our elections and that they're going to try to do it again in 2020, and they're doing it with our allies, and they're using disinformation to do that. And we do not have a counter disinformation strategy. This is something that I've been talking about since previously to the 2016 election. We need to have a strategy on how to deal with this kind of Russian covert action in the future, and we need to start those conversations now because our elections obviously are right around the corner.
Let me try to follow up on 2 points quickly if I can, because we're running out of time. Number one, sure. You say you do want Congress to hear from Robert Mueller, presumably soon. You acknowledge that's different than what we're hearing from Lindsey Graham and some Republicans, particularly in the Senate.
I don't know what they're saying on that topic, but I do believe that this can settle things by actually, we're talking about a report, one dude's opinion of a report written by another dude. Let's have that dude that wrote the report come to Congress and talk about that, and people get to ask him questions. And then, again, we should be talking about this disinformation strategy and how to deal with it in the future.
You may be the first person who's ever called Robert Mueller a dude.
I don't. No disrespect to the Attorney General or Bob Mueller.
No disrespect to any dude, for that matter.